It's scheduled today for a motion for summary judgment. I noted from the clerk, she indicated that Mr. Bopp and Ms. Graunitz are also scheduled for 9 a.m. on the protection order docket. So
They are.
maybe we could just touch base first on that. So I'm assuming Ms. Graunitz would like to be present. So would it be wise to pause and maybe just get an idea where they're at as far as their dockets before we proceed, or any thoughts you may have?
Well, I'm going last on that docket. So I've already explained to Commissioner Carmi that I'm on this docket as well. Let
Okay.
her know that if we could go last on that docket, and she said that was fine. I'm not sure if Miss Gronitz, I don't see her. Maybe unless she's in the courtroom, she's not on the Zoom for that because I'm
Right.
on both.
Right. And I'll double check with the court clerk. I poked my head into the courtroom too, where it's scheduled and it's noted to be today. I didn't see anybody in the courtroom, so I'll double check with Madam Clerk. Do you see anybody in the courtroom two?
There is no one in courtroom two, but people are allowed to go into the courtroom in the protection order docket, so she may be in that courtroom.
Okay.
I I don't. I mean, there are about 10 people in there. Um, I don't see her amongst the people. I do know she's returned about half of the items, so I doubt she'll be here today. It's just the remaining half that she hasn't. And she hasn't put in anything into the court file.
Right.
So
Right.
I would doubt she'll show up for this part because it's a very specific partial summary judgment. It's only on items purchased before 2018 that we're talking about.
Right. Right.
Um,
Um, so Ms. Winkles, you indicated that you're looking at courtroom or the protection order docket right now. You're looking at a
that's
list
correct.
of individuals.
Yes,
And
I'm looking at it.
do you see her name listed as one of the Zoom participants?
She is not listed, and I don't see her in the courtroom either.
Okay,
Um,
so you have a visual on the actual courtroom.
yes, I do. I have a visual in the courtroom as well.
And which do you know which courtroom that is?
Courtroom one.
Courtroom number one. I think what I may do, I may ask one of my assistants to just make an announcement in courtroom
Okay.
one for Mandy. How do you pronounce the last name?
Graunitz.
Graunitz. Winkles is present. Mr. Bopp is present. And it shows Mandy Graunitz is trying to join, but has not yet joined as of yet. Um, so I confirmed with my assistant. She went to Commissioner Carmi's docket, did not see Ms. Graunitz in the courtroom, um, and was Ms. Graunitz was also not on the Zoom call. I returned to my courtroom here, and I see that Mr. Bopp was here and Ms. Winkles was here, and that Ms. Graunitz is still in the process of joining. You know, when it says that a person is in the waiting room and then you admit them and then they're in process of joining. And at this point, the joining has not been successful. So I'm not sure what to do about that, other than I'm wondering if I can send a chat to her. No, it doesn't let me do that until she's actually part of the joined.
I I can email her real quick.
Okay.
What would you like me to say?
Um, oh, looks like she's in.
Oh, never mind.
All right, so she's in now. It's connecting to audio, so maybe another pause as we wait for that. 08. We have Ms. Winkles present representing Mr. Bopp. Mr. Bopp is here, and I see Mandy Graunitz is present also. Ms. Graunitz, can you hear me? Let's see.
Uh, did Manfred's, can you hear me?
Yes, I can, Ms. Graunitz. Can you hear me okay?
Yes, I apologize. I'm having some connection issues. I was trying to call in to get better clarity. I don't have the right meeting password, so if this works, I'll just go with this.
Okay, that sounds fine. We're here today for a noted motion for summary judgment brought by Ms. Winkles on behalf of Mr. Bopp. Ms. Winkles filed on behalf of her client, she filed a motion for partial summary judgment, also a memorandum of law, which is just one document. And then she filed a number of supporting documents. And it looks like those are served upon Ms. Graunitz. And then Ms. Graunitz, I didn't receive anything from you. Did you file anything in response to the request made by Mr. Bopp? Ms. Graunitz?
I don't believe you have submissions for this particular issue.
Okay, so the only thing I heard, you may have been speaking for a little bit. The only thing I heard was this particular issue, just that phrasing. So if you said something before that, if you could repeat it, please.
I believe we're going to run into connection issues. Is there a way to call in and get a better reception?
There is. If you...
I'm missing the meeting passcode. The passcode I have has initials, and it's saying it's the wrong one when I call in.
This is present, representing Mr. Bopp. He is also present. Ms. Graunitz is here. And just confirming, Ms. Graunitz, you can hear me okay with the phone?
Yes.
Very good. All right, so we're here today on a motion for summary judgment brought by Mr. Bopp via Ms. Winkles. I reviewed the motion for partial summary judgment and also the accompanying supportive documents. And I wanted to check with Ms. Bopp. Did you file anything? Because I didn't see anything that had been filed in opposition.
My filings have not been submitted to the court on this case. I've been working with the other cases and trying to work with the attorney separately. The issue at hand is separate property that she's arising. That's not technically the issue that we're facing on this case, but what I'm reading is that she's trying to identify Mr. Bopp's separate property prior to the CIR, and then we've had an issue of exchanging property. I've had his stuff, he's had my stuff. I've coordinated a third party to make exchanges for the separate property. So this motion for summary judgment is premature and not really relevant to what we're trying to solve on the case. But as far as property before the CIR, I haven't argued that. We just haven't identified what is and isn't separate property yet.
Okay, so at this point, what I have before me, Ms. Graunitz, is that I have Mr. Bopp's version of events, and the rule CR 56, Civil Rule 56, indicates that there has to be specific pleadings or affidavits that set forth specific facts showing that there's no genuine issue for trial. And that's kind of the standard we use. So if there's not a response, it says if the adverse party here, you're the responding party here. If you don't respond, it says summary judgment, if appropriate, shall be entered against that adverse party. So without any pleadings on your end, Ms. Winkles is entitled to judgment. Can you tell me?
However, this is a notice of unavailability. I put in a notice of unavailability 3 weeks ago. I've asked for a continuance 5 times so that she and I can get on board with each other about this. So the fact that there's trial today, it goes against my notice of unavailability.
Well, let me just read it to you, and because I had a question about that. When I read over I did notice your notice of unavailability that you did file. You filed 2 of them. I'll take a look at the most recent one, which was filed on October 20th. It states, please take notice that commencing October 12th and continuing through November 13th, Ms. Graunitz will be out of the local area and unable to attend in-person conferences, court dates, or the like. Petitioner, Ms. Graunitz, will maintain accessible and responsive to court matters via phone or internet. Petitioner will continue to actively work on case file resolution options during this period. So what that tells me is that you're not available for in-person. Like if we were to meet here at the Hall of Justice, you're telling me you can't do that. And then you're also telling me that you will continue to actively work on the case file and you will maintain accessible and responsive to court matters via phone and internet. So by your presence here today, I'm assuming that that notice of unavailability as filed applies because you're not here physically, but you're here electronically or via phone. So help me understand your position on that.
My position is I'm working remote. I have 80 hours of discovery to get to counsel. I've had a handful of court dates thrown at me and a handful of basically what I call red herrings, preventing me from getting her the discovery that I need to get to her. So in the last 2 weeks, I've had to field 100 hours of work to overcome the 80 hours of discovery. So everything that's happened in court, which is a handful of motions and gestures on opposing parties' part, knowing I'm not available, pressing for discovery, and not allowing the discovery process to take place. So I put in the notice of unavailability with the intention of working with counsel to get the discovery information to her that she needs to support her case, because she doesn't have the right support data yet in her possession, and I need to get it to her. And every time I have to come to court over a different motion, which has been a handful of times the last couple of weeks, it stalls this process of discovery. My priority is discovery. Her priority is pressing forward and not allowing it to happen. So I am requesting to have the discovery and have the cases actually match up, because her information is not true, not accurate. I have the true and accurate information, and I think that if she had the information, she could better position herself and her client.
All right, thank you, Ms. Graunitz. One question. It looks like on September 29th, there was a docket notice sent to you indicating everyone would be joining together on October 11th to choose a date for the summary judgment motion. On October 11th, Mr. Bopp was present, Ms. Winkles was present. You weren't here, so the court went ahead and set the summary judgment for this week. And then on October 31st, we met again after having the case be heard back on that date. Mr. Bopp was here, Ms. Graunitz you were here, and we set it for today, confirmed that they would happen today. So at that time,
this is the first time I've actually been able to log on. So I was present both those other meetings, but I wasn't able to actually have a voice in those meetings. And it's been communicated several times to get a continuance, both with Ms. Winkles and to the court office, because I was not able to get on, because I am unavailable. I'm working remote, and I don't have good service, and I don't have availability or a way to get to where I can until the 13th. So everything, all these court dates needed to be postponed until the time I could actually get reception to make it to the hearing and have a voice in the hearing. Because it's frustrating to hear you guys make these judgments and not be able to actually say anything when I'm sitting there watching it. I was there the last meeting. I couldn't unmute. And so they pressed forward and pressed forward. So we can continue to press forward, but it's not in Mr. Bopp's best interest to do that. And I'm trying to make it clear to his counsel that her pushing her agenda is not helping her client. Now, if she wants to push her agenda and make the summary judgment, I have to take repercussive measures to correct the efforts that she's putting forth to press this forward.
Okay.
And that doesn't look good for her client. So I'm in a position where I'm trying to help her client more than I feel like she's helping her client. And I'm about ready to check out, because I'm done everything on my part to be cooperative and to be assistive in this. And I'm getting nothing but pressing and resistance and a drive. They're wanting to drive this case. This case has 30 line items. The writ of replevin, which is consumed the majority of the time, has 80 line items. And then the protection order docket has about 60 to 80 line items. So out of the 3 dockets that involve Mr. Bopp, this case has been the most neglected, and now getting pressed forward above the other ones so that she can motion for separate property with the full intention of having me arrested for the property that I'm possessing of Mr. Bopp that I just unloaded at his house. So I'm looking for a fair and reasonable outcome. They're looking to have me arrested so Mr. Bopp doesn't have to have a divorce or pay me the 1099 he's outstanding from last year. I have a federal tax evasion issue I've been trying to resolve. I have to let the IRS know, are they taking measures, or am I fixing this here?
Ms. Graunitz, do you mind if I just interrupt just shortly?
I'm done.
No, it's okay. We were talking about your presence at a couple of different hearings. On October 11th, there was no showing that you were present. On October 31, there was a comment by the clerk that you were present but not responding, and that could have been due to internet connectivity issues. So I just wanted to make that clear. So we've heard from Ms. Graunitz. I'll hear from Ms. Winkles, please.
Yes, Your Honor. The issue I have is, even if she were present or even if she weren't present, the fact is that she has to submit something. You don't just get to go to court and say whatever, because then it's not properly before the court. So her duty, unfortunately, if you have a lawyer, if you don't have a lawyer, is to read the court rules. And CR 56 is written in such a way that it's pretty understandable. It's deadline oriented. It's you have to file a declaration or an affidavit confirming your side. That is what she needed to do. Even if she didn't show up today, if that were here, I wouldn't just get what my client's asking for, because then you have something before the court. You can make the determination based on the facts before the court. Her argument about she didn't know, she hasn't been able to argue, it's problematic because there's nothing before the court. We have nothing to go on. And I gave Ms. Graunitz a lot longer than the 28 days, which is the minimum. So she's had since September to put in something, and she's put in nothing. I, in fact, didn't think that there was a problem with this particular issue, which is why I kept pressing forward saying, this is such a small issue. This is the 2018 and before stuff. And I'm not asking for it to be returned. Obviously, this is not an injunction or anything of that nature. This is purely determining that anything 2018 before separate property, not capable of being distributed under a CIR. It's a question of law. Anything that was purchased before then, and we have a list. Now, I did expect maybe she was going to put a list in of things that weren't purchased before 2018. She did not. We did put in receipts and the like. There's no question of fact. You have no declaration here. You have nothing here. The court rule is very clear. Even if she weren't here, it wouldn't matter. Even if she came on the 31st, it wouldn't matter because nothing's before the court. So I'd ask Your Honor for a judgment that anything prior to 2018 that's on the list on Exhibit F that's listed as before 2018 is separate property, not capable of being distributed under a CIR, and therefore is not an issue. Then I can, obviously, the replevin, we can see what's actually been returned in that. Obviously, my client's stating that there's not a CIR. That is a question of fact that has to go before a fact finder. It's going to trial. The questions about discovery and the like, that's a completely separate issue. I'm not sure, there was orders in the other cases on when to turn that in. They haven't been met in any event. We're waiting on that. But this is such a small issue. It's a very finite issue. Whether or not they both agree on the date they got together, whether or not anything before that date is capable of being distributed in a CIR. And if the answer is no, and according to case law, it isn't, it's not like a marriage and that you can separate properties on the table. It's only during the marriage or during the CIR. If that's the case, then anything he purchased of the things she took before 2018 are separate property, and he's entitled to a judgment that those are separate property and they belong to him. And then we go from there. Whether or not they've already been returned, I'm not going to go for a replevin on them. If they haven't been returned, then I'll obviously talk to Miss Graunitz and Mr. Bach about that. But this is really just determining if separate property is capable of being distributed in a CIR. And if not, then that should belong to Mr. Bach, and that's it.
Thank you. So, Ms. Graunitz, what are your timeframes? What's the earliest timeframe you can have your material submitted?
Your Honor, I am not technically objecting to general property before 2018. However, there was a 5-year relationship, and the ownership of set items, specifically a handful of tools, are up for question. I have been working to try to return Mr. Bob's personal property to him since June. So in my opinion, this entire case is unnecessary and just excessive litigation. Once I can return Mr. Bob's stuff, I don't know specifically on the list what would even be up for question, because as far as I'm concerned, Mr. Bob is missing a bunch of his personal and sentimental effects from the remodel that took place in March, and I've been working to return those. I know a good majority of those items were returned this weekend. I don't argue to keep anything associated with Mr. Bob specifically. I don't want any of his personal items. So as far as going for the summary judgment, like I said, the whole purpose was to press the summary judgment because I have his possessions, so that she can chase after me with a written reprimand to say I stole his possessions, although they were transferred during a legal remodel. I have legal possession of his items, but I don't want his items, and I'm trying to return them, and I've had counsel in the way of allowing me to return his separate property. So instead of working with me to give him his stuff back, she's pushing all of these legal issues, driving up his costs. He's already paid her more than the property that he's arguing for in this case. So as far as making a judgment on pre-2018 items, generally that would be fine. But there's a handful of tools that I don't know. There's the things on the list. So if we make the summary judgment today of pre-2018 items being his, that's fine. I don't want her chasing after me with a written reprimand saying that these items are stolen because they're trying to invade my property and have the sheriff go up and do a search on my property for some other purpose that other than this. It's not about the personal property. I've been trying to get him back his stuff, and she's been blocking my way to press litigation. So my solution is let me give his stuff back, see what we're arguing about after the fact. But I've been stuck with his possessions in my spot, in my storage. My stuff is sitting out in the rain, has been all year, because his stuff is in my prime storage so that it doesn't get ruined, because it's a client project materials, and I take good care of any client's possessions I assume owners or responsibility for. So,
Can I ask you a specific
as far
question,
as I'm concerned, the full motion is unnecessary.
Can I ask you a specific question? There is an
Yes.
allegation that there's a boathouse purchased by Mr. Bopp in 2017. Are you contesting that?
No.
Okay. There's a contention that there were tools purchased tools and property purchased prior to 2018. Are you contending that those do not belong to him, or they do or do not?
A handful of tools land in the gray area. I know some of his bigger tools got returned. The table saw that with all of his large items that were easily identifiable for the third party to take back have been returned, in my belief, or that was what I was informed yesterday. So he has his table saw. I'd have to review the list, but as it is right now, his items are in my storage. I want them out, and I'm being blocked from returning them while also being chased after for theft. So I didn't steal anything. I'm not necessarily contesting pre-18. However, we did have a CIR. We worked together 5 years, and I have been using tools exclusively to run my business during that time. I don't necessarily want anything. It's a replacement value. We're arguing replacement value only, not the actual possessions or not the actual items.
Thank you, Ms. Graunitz. A follow-up question. You indicated that you'd need time to review the list of tools and property. How much time? This goes back to my initial question that I didn't hear a response to, of when do you think you would have your materials ready so we could have this hearing and make a determination, which may, if you get those materials in, may obviate or prevent the need for having the hearing. But I just need a general time frame when you feel you would have your response to the motion for summary judgment submitted.
The response can be submitted Wednesday. I have an agent available to take it to the courthouse. I have to email, because everything has to be paper submitted into court. It makes it challenging when I'm 2 hours away. So I can, Wednesday, I can have that paperwork in. Today, I have arrangements to go find good internet to upload all the files to give to Winkles so that we know what we're actually arguing over.
So you think by Wednesday of this week you could have your materials shipped off and submitted to the court and the other party?
I would like to say yes. I know by November 13th, or whenever my notice of unavailability takes place, I can make it back to the actual storage unit and finish getting the possessions that Mr. Bob has. So if we set a date 2 weeks from now, we can have much better standing on what we're actually contesting.
Okay. Ms. Winkles, so I'll just kind of tell you where I'm leaning. I'm leaning towards continuing the motion to a trial setting docket on the 8th of November at 1:30, choosing a new date for a summary judgment motion, which could be as heard as soon as, maybe the 20th or the 27th, I'm not sure, but I'm looking at that and just want to hear your thoughts.
Yes, Your Honor. I think my thoughts are going to be the same, just going off of the court rule. She had a certain amount of time. She's had that certain amount of time since, she had more time. She didn't do it. We keep giving her more time on everything. So if this had been the first time this had happened, I would say absolutely. And I'm very happy to give continuances. I'm personally not getting paid for this anymore because she's absolutely right. By now, it's gotten so much because of all these continuances that I can't charge Mr. Bopp anymore. But she's had continuances literally on everything for weeks and weeks. And so I'm just back in court every day. And so for me, I think the court rule should stand. She had a certain amount of time. She doesn't know if she contested or not. She could have looked at that property. She could look at it right now and tell Your Honor, this no, this yes, this no. I mean, it's not a very long list on Exhibit F. The fact is that she's dragging her feet, and it's costing me money at this point and me time. And it's cost Mr. Bopp money and time before that. So I'd ask that she doesn't get a continuance. Putting this back on the trial setting, it's just going to be the same thing. It's the same thing with the discovery. We've been put on, she's gotten 3 continuances. We've been put on. I still don't have it. So now I have to go back to court on that. It just makes this really expensive. And I can't justify it to somebody who's looking for 25 grand worth of property to have a 25 grand bill. It just doesn't make any sense. So I'd ask that it not be discontinued. It's prejudicial to my client, really prejudicial. And because it costs them so much. And Miss Graunitz has the rule in the book. I mean, you can Google it. And the fact is, she could have put a declaration in that said, I don't agree. And these are the things I don't agree on. And these are the things I do. It could have been 1 page. And she didn't do that. So I'd ask that we go forward today. But if we have to set it over, we'll live with it.
Okay, thank you. Well, I don't disagree with the notion that Ms. Graunitz could have filed something, could have filed a note that said, I disagree, or I agree with these certain aspects, I disagree with these certain aspects. But it's been crickets. We haven't heard anything. The paperwork clearly indicates that Ms. Graunitz needs to respond by a particular time frame. That time frame is passed. So I'm gonna put a filing deadline that any responsive pleadings to the summary judgment must be filed no later than Monday, November 13th. That's the cutoff date. So Ms. Graunitz, make sure you have it filed by that time frame. We'll be back here on November 15th at 1:30 to choose a new date for the summary judgment motion. I am also assessing $500 of attorney fees that Ms. Graunitz will need to pay to Mr. Bopp for the dilatory action or lack of action. So Ms. Graunitz, November 13th, that give me a little extra time. You said on the 8th you'd have it ready. So I'm going to give until Monday the 13th, close of business. Everything will need to be filed and shared with the other side. We'll be here on November 15th at 1:30 for the trial setting docket, at which time we'll choose the summary judgment motion date and the $500 for attorney fees. So I think that's any clarification or questions on that issue?
No, Your Honor.
Ms. Graunitz?
May I request that they stop putting in frivolous motions? I offered release to return his stuff, and she filed sanctions against me for discovery. So I'm trying to return the things that we're arguing about while she's trying to sanction me for not responding. So every part of her litigation has been counterproductive for her client because all she had to do was allow me to return his items in June and not press all of the excessive litigation. So in this particular case, what you have in front of you is very little information. But on the other cases that she's been preoccupying my time with, she pulled in the protection order docket when it was supposed to be sitting idle and I wasn't supposed to be attending to it. So I've had to give 50
Mr.
to
Graunitz,
60 hours to that docket.
I apologize for interrupting. My question posed was, do you have any questions or clarifications related to the court's order today? A set of the deadline for filing, the date for coming back for the summary judgment motion, and the $500 attorney fees. Any questions or clarifications about that?
What I hear you say, Your Honor, is Monday the 13th, I need to have my response to the summary judgment turned into the court. We meet again November 15th at 1:30, and I'm getting charged $500 attorney's fees. Is that correct?
Yes.
Okay.
All right. Hearing no questions, that'll conclude the hearing today. Thank you.
Thank you, Your Honor.
Are we still doing the protection order?
Yeah, the protection order, my understanding is that it's that it was arranged beforehand and that that's still a go in the different courtroom.
Yeah, and I'll be moving over there now.
So do I log off and you log on to something else for that, or do we continue that?
You'll have to go to
docket, right?
Yeah, it's a different docket, so you'll have to go to the court website and find the protection order docket link and or phone number, and scroll all the way down to the bottom to make sure you got the correct meeting ID and code.
Okay, they were just at the exact same time, so it was really poorly scheduled.
I think it was scheduled perfectly, and then we've made accommodations for everybody to participate.